Namaskar student. In previous video we had talked to the introduction of criminal justice and arrangement of chapters. Let's take a quick glance. We had talked about somehow when a crime is committed, somehow it is reported to the police, and then second topic is investigation, third topic is commencement of proceeding or start of proceeding, fourth is compelled to appearance. The accused is compelled to appearance before court so that the hearing is started. And the last is conduct of trial. In this video, we will talk about how is crime reported to police, which is covered by chapter 12 and 14. So let's start this video. Before getting started, I request you to please subscribe my channel The Legalistic to get information. So based on serious before we go further to report to police, we should first know that on the basis of seriousness the offense is divided into two categories: cognizable offense or non-cognizable offense. This division is very important in CRPC as the manner of arrest and the manner of investigation both is different under these both categories. First, we have to know the cognizable offense. The offenses which is of serious nature and involve punishment of death or life imprisonment, like murder, rape. Such crime is of serious nature, and in such crime the accused get death sentences or life imprisonment. Cognizable crime is defined under section 2C of CRPC, which say the offences for which a police officer can arrest, and this is the most important line. Again I repeat, the offences for which a police officer can arrest someone or accused without a warrant, means police doesn't need any arrest warrant. The police arrest without warrant and begin investigation without the permission of a magistrate. The police doesn't need the permission of magistrate to investigate. The police start the investigation without the permission of a magistrate. Now moving further, non-cognizable crime. The offences which is of less serious nature than cognizable offense, and police can't arrest, again repeat, police can't arrest without warrant is called cognizable offense. Means minor crimes such as theft, defamation, such crime is considered as non-cognizable offense. In such cases the police can't arrest without a warrant, means the police need magistrate permission before arresting someone. It is defined under section 21 of CRPC, which say the offences for which police officer have no authority to arrest. No authority to arrest means police can't arrest without warrant, and police can't begin investigation without the permission of a magistrate. So basically, in cognizable offense, the police can't arrest without warrant and can't begin investigation without the magistrate permission. In non-cognizable offense, the police in cognizable offense, the police can arrest without warrant. The police can arrest without warrant and start investigation without the magistrate permission. In non-cognizable offense, the police can't arrest without warrant and can't start investigation without court permission. This is the main difference. and very important difference. Again, I repeat, in cognizable offense, police can arrest without warrant and start investigation without permission of magistrate. So in cognizable offense, police doesn't need court permission to arrest or investigation, and in non-cognizable offense, police need permission for arrest and permission need for investigation. This is the main difference. Now moving further, chapter 12, which is with chapter 12 and 14. So now we start chapter 12. In chapter 12, we will study two topics. First, information of cognizable crime to police and information of non-cognizable crime to police. Means first we would know how cognizable crime is reported to police and how non-cognizable crime is reported to police. So first we will move cognizable offences. The information of cognizable offence to police is deal with section 154 of CRPC, which title as information of cognizable offence to police as to registration of F.I.R. Before we go further, very important question is, what is an F.I.R.? F.I.R. is a written document containing the first information of an offence reported to the police authority by an informant complainant to set the criminal law in motion. Again I repeat, F.I.R. is a written document containing the first information of an offence. Means if an offence is committed, the first information is F.I.R. reported to the police authority by informant or complainant. Here the word informant and complainant means the informant or complainant have knowledge about the commission of crime, and the informant and complainant go to the police and give information to police with intention to set the criminal law in motion. So this is the F.I.R. Second, it is a written document paragraph stating that description or narration of first sight. It is a written document paragraph stating that description or narration of first sight or knowledge by informant or complainant. Means consider with an example. If a person come to the knowledge about the commission of a cognizable offence, on the basis of his knowledge of his first sight, he can file the F.I.R. about the commission of that crime. Third is, the police started its investigation upon the information mentioned in the F.I.R. Means what is the written in F.I.R., the police started the investigation with that. Fourth, it is first indication to the police why it is first indication to the police by any source about the commission of an offence from any source. Next is, the police come to know about the commission of an offence through the F.I.R. and the police authority is bound to investigate and find the truth of that incident. After the F.I.R. is being registered, the police is bound to investigate and find the truth of that incident. Now moving further, let's see of the language of section 154 CRPC. So you can see this total description is of section 154 CRPC. We will learn this total section in very simplest form, step by step. So let's read one by one. Please listen carefully. On subsection 1 of section 154 CRPC, we are talking about this subsection 1. The FIR is registered on the receiving of information regarding the commission of cognizable offence. By this subsection, it is understand that FIR is registered in the cognizable offence, means FIR is registered only in cognizable offence. After registering the FIR, the police read over the content of written information, complaint or FIR to the informant and complainant. Means after registration, the police orally inform the informant or complainant about the content of the FIR. Third is the written information, complaint, FIR shall be signed by the person giving it. Means whoever the person giving the information about the crime has to sign the FIR. Next is subsection 2. Subsection 2, as we see subsection 2 here. So a copy of the written information or complaint or FIR shall be provided to the complainant, informant and free of cost. Means the police can't charge, the police is bound to provide free of cost a copy of the written information, complaint or FIR to the complainant or informant. Next is proviso. So you can see here is a proviso, first proviso here and the second proviso is here. So proviso is reporting of certain categories of. See, in section 154 CRPC there is a category of certain offences. So certain offences, these categories involve this section 326, section 354, section 354A, section 354B, section 355. These all section of a crime is under 154 and the same is here. So this is a category of offences under section 154. So these certain categories of offences, if it is reported by the women, if this certain crime of reform, if this certain crime category of offences is reported by the women victim, then such information or complaint shall be recorded by a women police officer. Means as above mentioned, certain category of offences, if it is reported by women victim, then such information or complaint shall be recorded by a women police officer. If it is reported by the disabled person, which is mentally or physically victim, means if a mentally disabled person, physically or mentally, report the commission of these categories of offences to the police, then such information shall be recorded by the police officer at the residence of the victim or place of his or her choice. So this is the section. Now in both cases, as per subsection 1 clause B, the recording of such information shall be videographed. Means in both cases, by women victim or by disabled person, in both cases if crime is reported, the recording of such information shall be videographed. Next, as per subsection 1 clause C, the police officer forward the statement along with the victim to the judicial magistrate for recording of such statement under section 164 subsection 5A clause A as soon as possible. As per section 164, the police officer forward the statement along with the victim to the judicial magistrate for recording of such information. As in both cases the information is very critical, so the recording of such information by the magistrate is very important. Now we will discuss about a case, what if police refuse to register the FIR. So this is talked about in subsection 3 of section 153 APC. The complainant on the refusal of registration of FIR by police, the complainant may approach or send written complaint or email to the concerned superintendent of police of that police station. The superintendent of police is empowered to make the investigation or direct the investigation by any police officer subordinate to him. So if a person approach the police and request to register the FIR, however the police refuse to register the FIR, the police can approach the superintendent of police of that police station and request him to register the FIR. The superintendent of police, on receiving the request, he can himself investigate or direct or investigation by police officer subordinate to him. And if this also fail, the other alternative is the complainant may approach the concerned magistrate under section 156 subsection 3 for direction to registration of FIR or for an investigation under section 156 subsection 3. Under subsection 1563, the magistrate is empowered to direct the police to register the FIR and investigation on that FIR. Section 156 subsection 3 is very important, as it grants a special safeguard to the victim or informant or complainant who want to lodge the FIR. If the police, even superintendent of police, doesn't register the FIR and doesn't refuse to register the FIR, the person approach magistrate for direction of registration of FIR. The magistrate direct the police to register the FIR and start the investigation. So section 156 subsection 3 is a very important section. So this is a very short video. In next video we will discuss some important case laws related to FIR. If you like this video, then please subscribe and share this. I know this is my first video, so there may be some mistake. I kindly request you to please forgive me for that. This is my beginning as a YouTube, so I request you to please support me so I can provide you more information about law.